Good evening and welcome to this edition of Board of Adjustment regular meeting held today on December 7th here at 4 o'clock. I now call this meeting to order, and our first order of business is the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, there's not much on our agenda today. The first thing we're going to do is a special presentation. We're going to welcome our new member, and forgive me for getting the name right or wrong, David Bonagaski. Is that pretty good?
Yes.
All right, David Bonagaski is a new member of the Board of Adjustment. The next order of business is the approval of minutes from March 2nd, 2021. Do I have a motion or any kind of changes for the minutes of March?
I'll make a motion to approve the minutes as presented.
Okay, we have a motion to approve the minutes of March 2nd, 2021. Second.
Who seconded, I'm sorry?
I did.
Okay.
Okay. So we've approved the minutes of March 2nd, 2021. As far as a public hearing, I don't believe we have any. Patrick, do we have any announcements or discussion items to consider?
So we have one discussion item, primarily for our new members' benefit. I have a PowerPoint that provides a little bit of training and background as to what the Board of Adjustment is, what kind of decisions it makes, and within those decisions, what are sort of the things that you can consider and the things that you probably shouldn't be considering as opposed to this. For the rest of you, this may be kind of something you have seen before, but it's always good to have a refresher. And then at the end of it, if you're interested, I can begin working on putting together a presentation to walk you through the comprehensive plan that we adopted this past June to talk about, the city's new goals and objectives. This was the first update to the comprehensive plan that the city's undertaken since 2001, so it was long overdue. And it's a remarkable document, and I can provide you all copies of that and copies of the new Unified Development Code that was an outcome of that comprehensive plan update, and kind of walk you through all of this at the next meeting if you're interested in that. But in the meantime, I do have this presentation on variance practices in Canyon City. So without further ado, let me begin. So, Board of Adjustment is responsible for particular areas in the land development process that don't really fall within the realm of City Council and Planning Commission. What you're looking at here on this map is an organizational chart that shows sort of the pattern, the path that development follows from the very beginning at annexation and zoning all the way through to, although we've got our captive text at the bottom, but it goes all the way to building permit and certificate of occupancy. Well, within that area, you have the zoning component, either annexation and zoning or a rezoning request. These establish the rules for how a piece of property can be used. Height and bulk limitations, all of the setback requirements, what is and is not allowed on that piece of ground under zoning. You also have the major development processes. These would be subdivision and site plan. And these confirm that the lots that you're creating conform to the minimum lot sizes that are required under zoning. It confirms that you are not creating a lot that can't possibly meet setbacks to have buildable area associated with it. With the site plan, you're now putting into place the specific performance criteria that a particular use may have, such as how much parking will the use require. How much landscaping will go in on that property based upon how much of it is going to be building mass and how much of it is going to be parking lot. All of these things get factored into a site plan. Well, where variances tend to occur are when a conflict comes up between the zoning on the property and the subdivision or site planning of a parcel. Now, this conflict usually has to be to such a degree that strict conformance to the requirements of the zoning or development standards of the code would render the parcel undevelopable. That's a key distinction. An applicant can't come and say, well, you know, your requirements under your Unified Development Code state that I'm gonna have to put in 30 parking spaces for this building that I wanna build, and that's just too expensive, I don't wanna build that. That is not a reasonable excuse for a variance. Reasonable excuse for a variance would have to do with a hardship. The American Planning Association defines variance as a request to depart from the literal requirements of a zoning ordinance. This can include relief from setbacks, height limits, parking requirements, landscape requirements, or some other specific performance requirement that has to occur, that the code says must occur on site. Now, this is where the acid test for these requests for relief come from. This is in the form of a hardship. Now, as I said, hardship cannot be measured in financial terms alone. The complaint that it's simply too expensive to comply isn't a sufficient reason to declare that there's a hardship. Now, items that do potentially qualify as hardships include things like undersized lots. There are plenty of examples of lots in Canyon City that, because they were created before we even had zoning, don't conform to the minimum lot size requirements under the zone district they happen to be in, and therefore are considered legal nonconforming. But what that means is, because they are undersized and provided with a zoning request, you have to take into account that they can't comply with maybe some of the setback requirements that would come under that zone district. You also have the situation where you have lots that have an unusual shape or topography. We've got a lot up here on, I believe it's North 3rd Street. There was just a fire in this particular building. But this is on a lot that was a very strange triangular shape and only took its access off of an alley. It had no defined street frontage onto a property. So the rebuild on that's going to be a bit tricky. I don't even know if they intend to rebuild because, as I understand it, the owner of that property is currently incarcerated. But that particular property would potentially be a candidate for a variance request if someone decided to rebuild on that lot because it is of an unusual shape and size. Lots with significant historic resources. Well, Canyon City is about to hit its 150th birthday. There's a lot of history that goes into that, and to the extent that we have a comprehensive plan that has deemed certain historic resources as very important, that would be a reason to preserve a particular property and therefore deviate from the sorts of things that the land use code might require a particular property if it's undergoing redevelopment to have to comply with. The third thing would have to do with things like the Endangered Species Act, where you've got wildlife, riparian areas with either threatened or endangered species of animals or plants. Those riparian areas would constitute a no-go zone. The federal government would say you can't go in there. In fact, you're going to have to provide some mitigation on your own property that's outside of this riparian area so that when you're under construction you can't do any, you won't be doing anything to damage that riparian area. That's going to potentially affect what you can do with a property. If all of a sudden you lose half of a piece of ground because it's riparian area for the Prebles Meadow jumping mouse, for example, well, what does that portend for your ability to put parking in there? Because in order to build the parking, you'd potentially be disrupting the habitat area. So those are the criteria of things that, you know, rise to the level of a hardship for which we would accept a variance application. Mm-hmm. Certainly.
So just for clarification, like the planning commission could grant these variances?
No.
No, they could not.
Board of
It would
Adjustment
be-
is the only entity that
Okay.
can grant these, and as I'll explain in a couple of slides, there is no appeal to the Board of Adjustment. If the
Okay.
Board of Adjustment makes a finding for denial, that's the end of the process. They can't go to council and ask council to overturn the decision.
Right. That I understood. I was just curious if we were like the Court of Appeals for, like the Planning Commission said, no.
You are the decision-making body when it comes to variances and appeals.
Just clarification.
If
Thank
the
you.
council found that unacceptable, could they not take this to district court? and have the district court hear their displeasure with the conclusion of this board?
I suppose it could. I would have to defer to our city attorney as to what legal remedies council may have to a Board of Adjustment decision that the council disagrees with. Fortunately, we've never had that situation
Yeah.
come up in Canyon City. Again, we've got a municipal code that I think was voter enacted that makes this separation, and I think the only way you could potentially revise that under the municipal code would be to go back to a vote of the people to say that potentially decisions of the Board of Adjustment could be appealed to the city council. I don't know that anyone has decided they want to go forward with that. I don't know that there's any impetus to start such a petition, so as it stands right now, the Board of Adjustment's decisions are final.
Thank you.
So the final thing you need to remember about variance is that they have the potential to grant something called precedent. What that means is, when you've granted that variance, given the particular factors of that situation, whatever the unique hardship that exists on site is, whatever the relief or waiver from the UDC that you are granting with that variance, you have punched a tiny little hole in the city's ability to enforce the Uniform Development Code as it stands. Now, what that means is if another project happens to come along with exactly the same situation, we would be hard-pressed to deny that request because a precedent has been set. Now, again, in a lot of cases, the distinction between how similar are these two cases, that may be something that a lawyer would have to determine. But for the purposes of this training, it should just be understood that variances have the potential to create precedent, and that precedent has a spillover effect into how the city enforces the land use code. Now, variance requests are considered quasi-judicial, and this is where I begin to veer a little bit into Catherine Sellers, our city attorney's realm of expertise. They are specifically by zoning code left to the Board of Adjustment to consider. This consideration occurs as part of a public hearing. You saw that on the agenda. We don't have any public hearings this evening. But a public hearing is something that has to be noticed before the public. That notice usually takes the form of a mailed notice that goes to all property owners within a particular radius of the property, or in the case of variances, those properties that are just immediately adjacent to and touching the subject lot. It also requires that a sign be posted on property noticing the hearing date and time, and that we've now discontinued the practice of doing a published notice in the newspaper. We now publish notices on the city's website. So with those three requirements for notice in place, the public hearing is set, the public is adequate notice that the hearing is going to be conducted, it can come forward to the Board of Adjustment, and you can actually conduct the hearing and take public testimony in this quasi-judicial setting. In order to have proper notice to conduct the public hearing, and here I'll reiterate what I said a little bit, notice of the public hearing must be published in a local newspaper or circulation. Well, we don't do that anymore with the Daily Record. What we now do is publish on the website at least 10 days prior to the hearing date. Written notice must be mailed to all property owners whose parcels are immediately adjacent to the property under consideration for a variance, again, at least 10 days prior to the hearing date. An adequate notice is jurisdictional. If we cannot make a finding that adequate notice was done in a timely manner prior to the public hearing, the city doesn't have jurisdiction to act at that point, which effectively means that the hearing can't be held and it has to be rescheduled and continued to a date to make sure that that notice has been done properly. Now, when it comes to what it is fair to look at when you're evaluating a variance request, some of the things that are fair to consider include the variance criteria that are specified in the land use code. And when it comes to drafting a staff report, I will summarize those criteria as they are written in the code and give you, my interpretation of what this means. You are obviously free to disagree with that and develop your own interpretation, but you will have that information as a resource in your staff report. You can also look at the advice of regulatory documents, such as Title 17, the zoning code. which includes the subdivision and site plan development standards. Points raised by members of the public who are either appearing for or against the application to speak about the perceived hardship that exists on the property. That is relevant testimony that you can take into account. The quality of the proposal and how well or unwell it answers questions and depicts the applicant's case for hardship. What the applicant is ultimately doing as part of this quasi-judicial hearing is trying to make the case that they have a hardship that makes building the property as the code says it should be developed based upon the use that they want to put there. It's physically impossible. Okay, that hardship makes it physically impossible. So they're trying to build a record for this. They will have a narrative that they include with their application. That will be part of what will be in your staff report. You will have my staff findings as to whether or not a variance situation exists on that particular piece of property. You will have the public testimony that you can go off of. All of those begin to inform your decision as to whether or not you think a hardship does in fact exist on the property. Then the applicant's proposal in context to surrounding lot uses, lot configurations, and building. It may just be that the reason that they are in a hardship condition is that they're trying to overdevelop the land for what could otherwise go there. They could put other uses there that might not necessarily require the amount of parking that the code says they need to put there, but because they want this particular use, that's a problem. And it may be that that particular use they want to put there will create conflicts with surrounding land uses because of its intensity or its hours of operation or noise and fumes that the use may generate. It's all relative to the specifics of that particular case. And then the impact of the proposed variance request upon the neighborhood. And this goes back to the issue of possible conflicts between the proposed use and what existing uses are already there. I think it's fair to say that existing uses sort of have a right of prior claim because they were established before. Now, there's new uses proposing to come in. If it's going to potentially create conflict with the uses that have been there for a while, that's fair to think about. That's fair to consider in your deliberations. Now, oh, and finally, whether adequate public notice has been given. Again, that's jurisdictional. Now, what's not fair to consider as part of a variance request? Money spent on the preparation of the application materials or in advocacy for or against the project. How much money the applicant has spent putting their case together to convince the Board of Adjustment, how much money the opposition to the variance has spent trying to put their case together to convince you otherwise that it shouldn't be. The amount of dollars that they've spent in preparation for the hearing, that's not a relevant factor. Claims of property owner sovereignty. Well, okay, I get the point that people say, I am the Lord, you know, this is my castle, I am the Lord of my castle. That's all fine and well, but we all also have to live with a zoning code and a subdivision code that has certain specific requirements that as a property owner in Canyon City, you've got to be beholden to. If someone simply comes and says, well, I'm not going to do it because I'm the property owner of record and I don't think I should have to. That's a sovereignty argument. That's not really, that's not really relevant. The applicant's time spent in Canyon City prior to submitting the application. You will probably hear at some point that an applicant or perhaps an advocate for or against a project has been a Canyon City resident all their life. It's very nice to hear, but it doesn't have much to do with the merits of the case itself. Personal feelings about the applicant, the consultant, or the neighborhood or district where the property is being proposed. There are always going to be individuals who rub you the wrong way. There are always going to be parts of town that you don't feel particularly comfortable going into. And if an application comes forward that involves a person or place that you are uncomfortable with, I understand, but you can't use that as a factor to be held against the applicant. In quasi-judicial matters, personal like or dislike on a project is not relevant. What matters is whether the project can be found to meet the criteria for approval. And again, in a variance context, I will provide you with the variance criteria in the staff report, and that will form part of the basis of the finding of fact. Findings of fact are kind of important because if a decision ever gets challenged in court, what we have observed is that most courts do not like to superimpose their judgment on the findings of fact of a local elected or appointed body who is empowered with making these kinds of decisions. They're probably only going to act if they can find that there was a violation, for example, to the notice requirements, set those notice requirements aside, and set the matter back to the proper board or commission for a redecision of the matter upon proper notification for hearing. Now, at the conclusion of a public hearing, the Board of Adjustment is the decision-making body for variances. The decision of the Board of Adjustment is final, and there is no appeal of a Board of Adjustment decision except to the courts. The Board of Adjustment has 4 options when considering how to dispose of a project following a public hearing. You can continue it because you don't feel you have enough information, or perhaps because there may be a problem with the notice and you want to get that corrected before you actually conduct the hearing. You can approve the project, you can approve the project with conditions, or you can deny the project. Those are the 4 options that you have when a public hearing comes before you. Citings of findings of fact in a variance decision are extremely important. Not only do these provide the context of the decision, they can help to limit the precedent being set in the case of an approval or a conditional approval. As I said, they're also very useful for if a decision goes to court, defending that decision. Most judges do not want to put themselves in the position of second-guessing what an elected or appointed board decided at the time of the public hearing. If they have a set of findings of fact that they think are firm, they're not going to touch it. Then ideally, granting variances should be rare and should only be based on the specific hardship conditions that may exist on a parcel. Variances are not meant to be brought to broadly modify zoning. They are jurisdictional in nature, and as a result, you've got to be very careful about the fact that if you set a precedent, because you've now done something to uses in the R1 zone, does that spill over to affect every R1 zoned piece of property citywide? That's the real problem with setting a precedent. So that's my presentation, sort of my introduction to the process of deciding variances. I'm happy to answer any questions. I would point out that I sent a separate email after the agenda packet. It was a confidential email. It was from our city attorney regarding the conduct of quasi-judicial hearings and how to avoid putting yourself into a situation of ex parte communication or some sort of a conflict of interest, not prejudging a matter. So if you've got any questions about that, I'm happy to make sure that Catherine couldn't be here today, but I'm happy to make sure that the next time we meet, she can be here and she can speak to the issues of conduct of a public hearing and not being putting yourself into a case of a conflict of interest.
Do any of the members have any questions? I think we're good with that.
Can I make a comment?
Yes, sir, please.
I think it would be very, very wise to have the attorney to give us guidelines, sort of railings to stay, but what not to go, what line not to cross, so that we're very well aware of that, don't create a problem.
Certainly.
I believe she's done that in the past where she's zoomed in and
She indicated she had client meetings all afternoon today and would not be available this afternoon.
Okay.
But I am more than happy. The next item on your agenda is actually the 2022 calendar.
right.
So the next regularly scheduled meeting for the Board of Adjustment is going to be January 6th. That, I think, is also going to be the date of the first council meeting of the year, because that Monday happens to be when the city observes New Year's Day. So I would recommend our next meeting probably ought to be set for February 3rd. There's going to be a big reception here for the new council members that are being sworn in that evening. So I'm going to suggest that probably our next meeting should happen in February.
I would approve of that if all the members are good with it. Next meeting on 3rd of February, 2022. And at that time, can we start looking into the election of the officers as well?
Absolutely.
So we can do that. And if we can have Catherine come on Zoom and just answer any questions that we may have. All right.
Certainly. And I will resend her memo again
Yeah.
before the meeting on the 3rd.
Any other questions of the board members here? You have anything else, Patrick, we need to talk about?
You do also have in your agenda packet the dates for 2022 for the Board of Adjustment meetings. You can add those to your calendar if you'd like. Other than that, I am open for any questions, or if you would like to declare an adjournment, we can certainly do that too.
Welcome, new members. Appreciate y'all coming in. If there are no other questions or any concerns, I'll go ahead and call this meeting adjourned.
All righty. Thank you, sir.
Thank you.